Hi, Assalamualaikum warahmatullahi wabarakatuh. So today, my partner and I, Norlana binti Rosli, would like to make an presentation about records retention requirement for law firms and legal department. Firstly, laws affecting records retention. Certain laws dictate how specific professionals are responsible for managing individual record. For example, lawyers and attorneys are bound by attorney-client privilege, which protects the confidentiality of communications between a lawyer and their clients. Additionally, there are regulations governing the handling of legal documents and case files to ensure their confidentiality and proper management. Records that are not theirs may not be destroyed without the owner's consent, even after being copied onto microfilm. This is because record keepers are only custody for the record's owner. There are specific laws about how long legal files must be kept, except for records that belong to client and are held in a custodial or fiduciary role. An organization will keep records according to its business need because there are no specific law. Secondly, legal consideration. Law firms usually retain client record for a minimum of 3 years to safeguard against legal malpractice claim. Concerning double jeopardy, keeping record after settling a case can prevent the same or similar issue from being raised again. Legal consistency happen when legal department retain legal opinion to set the rules for the organization, ensuring they provide consistent answer to future questions. The third one is impact of attorney-client privilege. Client-related records are typically protected and cannot be requested by opposing parties during legal proceedings. Attorney-client privilege often maintains the confidentiality of specific communication between attorney and client. For private law firms, the attorney-client privilege may not always apply, and they can seek records related to the work done by the firm, especially in legal malpractice cases, within a specific time frame.
The obstacles of restoring record, based on what the article said, is that one of them is attorney, whether in legal department or private practice, often overlook potential cost reduction, such as budget rarely concern legal entities. Secondly, the attorney-client privilege protect client records but not internal use document, which means that it typically does not protect internal use document created by either the attorney or the client for their own records or internal decision making process unless those documents contain privileged communication between the attorney and client. In other words, while client records and communication are generally protected under attorney-client privilege, internal documents that do not involve communication between attorney and client may not be covered by this privilege and could potentially be subject to disclosure in certain legal proceeding or circumstances. Last but not least, attorney reluctant viewing efficient record management as time-consuming may impede the implementation. Recommendation for record retention. Firstly, establish a traditional record retention program. Secondly, establish a minimum 3 years retention period for case files. Thirdly, create a reference file for written client material after cases are closed. And fifth, establish reasonable numeric retention period for each type of legal file. And lastly, discourage attorney from reviewing files before the distraction. Benefit of record retention program for attorney. First, relief from the burden of reviewing case files. Second, maintenance of client record for the necessary period. Third, quick access to valuable client information. Fourth, increase law firm profit and reduce legal department expenses. And lastly, availability of valuable research and reference information.